morning. Good afternoon now. Welcome, everyone. Let's see if I recognize any names on here. I do recognize Stephanie, Yolanda. How is everyone this afternoon?
Good morning, Deborah. Hi, Deborah. Oh, sorry.
Okay, all right. We have to set some ground rules. I have been gone for 3 months, and this is my first broker strategy back. I need energy. So how is everyone?
Doing great,
good.
Deborah.
How are you?
Good. That's better. That's better. All right.
I think we were echoing. We were both trying to get it in.
Oh, okay.
Yeah.
So you can see me and you can hear me.
Yes.
Good. I haven't forgotten how to use this device here. All right. As I said, if you're just logging on, this is the broker strategy call. It's held twice a month. I want to start off by saying, number one, I missed you guys. And number two, for those brokers that stood in for me while I was out, thank you so much. I appreciate you. And I know that you guys had learned a lot of good things while I was out. If you are new to this call, this is a monthly call. It's held twice a month on a Monday from 12 to 1. And this is really your call. A lot of times we don't have a subject matter and we just open the floor for you to ask your burning broker questions, or I will have a topic that comes up quite a bit in a lot of the market centers. I am the managing broker in the Midtown office. I also have a team, a husband and wife team, a couple of assistants. And I've been with Keller Williams since 1999. I've been licensed for 27 years this July. Now, I'm only 27, you do the math, all right? So at the end of the day, we are going to talk about, the subject is a couple of things. As we go into this new market, there are some things that we're forgetting in our license law, code of ethics, and what contracts we can use to protect ourselves. So I've got a couple of topics here. Before we get started, if you will go and add into your device, let me go ahead and pull up my PowerPoint so if someone can tell me if they could see it once I get it up. Let's make sure my internet and everything is working fine because I tested this a million times this morning. All right. Can you see the PowerPoint?
Yes.
Wonderful. So you'll notice it says you can use your web or phone, meaning you could be on your laptop, tablet, or desktop PC and type in pollev.com/dblue224. Because we are going to do a little competition here to see how well you know your license law, code of ethics, and what forms you should use or what script you should use should this happen to you. And I've picked a couple of things that, again, like I said, are either happening now in other market centers as well as ours, or you probably will run into it. We're in a, I never say it's a bad market. It's a wonderful market when you've been doing this, you know, every day that we can wake up and sell real estate is still a wonderful market. It might be a little more challenging, but that's why you hone your skills. And I commend all of you that are on this call today. So before I get started, are there any burning questions? Any comments or feedback before I get started? All right, I will take that silence as a no. I also am not very formal and I don't have, I don't know that I have somebody on that can watch chat for me. So if you have a question, you can just unmute yourself and I will let you have the floor, okay? Those are the ground rules. All right, so let's get started. We're going to talk about 10 things that you should know about your license law and you should know about your code of ethics, or your colleagues should know. So with the poll that you signed up with, you should see the poll showing up on your device or on your web page now. Do you see that? You should see a question that says, can you negotiate a commission on a purchase and sale agreement?
No, I don't see it. It just says broker chat March 2023 on mine.
Oh, it might be a little slow because I've changed the screen. Does
Okay.
anybody else see the question?
Here we go.
I can see it.
Okay, wonderful. All right, so can you negotiate a commission? And these are all yes or no questions. And I will give an attorney note. There are no gifts or prizes at the end of this competition. All right. So can you negotiate a commission on a purchase and sale agreement? You have 20 seconds to answer this question. You're welcome to be anonymous, or you can put your name in.
Oh, you know what? Okay. All right. When you say that, negotiate, I mean like on paper, right? Like, can you write that into
It
it?
says on a purchase and sale agreement.
Okay. Well,
That's a yes or no. We're going to talk about that. Ready for the answer? Ooh, 67% said yes, and 33% of you said no. So I want to talk to the yeses. Why do you think you can negotiate a commission on a purchase and sale agreement? Anyone unmute and tell me why? No shame here. This is a safe place for us to learn.
I was thinking, this is Chris. I was thinking it could be put in
Chris.
special steps. Hey.
So give me an example of what you would put in special steps.
All parties acknowledge and agree, buyer's agent to be paid XYZ.
Okay, but this is not a CE, so you can say your commission if you want.
Oh,
All right.
okay. 10.
So anyone else that wants to help Chris out, make a comment about this question.
I mean, I thought it was negotiable too, just because so many things can be negotiated with the purchase and sale agreement. And I guess after I got it wrong, I guess it needs to be negotiated on the buyer brokerage agreement, not on the purchase and sale agreement, right?
So let's get the answer. So it could be yes, it could be no, and here's why. Under license law, we are not allowed to negotiate with a third party. Who would the third party be? The buyer, the seller. Those would be the other parties. We can negotiate our commission with the listing broker, okay? And that listing broker on your behalf can go back to that seller to say, you would like 1% more or something like that. What you can do in the purchase and sale agreement, you can say all parties acknowledge that the commission has been increased by 1%, if you want to do it that way. And it is best practice to use the ICA, which is the instructions to the closing attorney, to say, okay, in special steps, even though this form said that I'm going to receive 3%, I'm now going to receive 4%, and we put that in the special step. But if you want to be sure that there's no switcheroo, okey doke, that type of thing, then you would add that in the special step of a purchase and sale agreement. So don't ever let an agent tell you you cannot negotiate your commission. You can negotiate your commission. What you cannot do is negotiate that commission in the offer going back and forth. You can only acknowledge once it's been agreed upon. Does everyone understand that? That's why I said there's a yes and a no. But that was a trick question, so that was a warm-up, so get ready. Any questions about that, concerns, scratching your head or going, oh my gosh, I wish I knew this last year?
Okay.
So
Okay, go ahead.
You can go ahead, Chris.
okay. So basically you're saying that instead of me putting acknowledge and agree, then I should just say acknowledge.
Well,
In the
yeah,
special
no,
step.
exactly.
Okay.
Because what you're doing is you've already negotiated it on the side.
Okay.
Seller said, okay, go ahead and give her the extra percent. Listing agent said, yes, you can have the extra percent. Then in that offer going back and forth, you can acknowledge that.
Okay. Okay.
But you can't say, I'm Keller Williams and this 2.5% commission is too low. I want 3 and put it in the contract. Because see, when you do that, and when many agents do that, they're doing that for a reason. Because the buyer is like, you should get more. And the seller's like, no, you shouldn't. And so you want to put it in the contract like you're negotiating the refrigerator. You can't do that. You will get sanctioned on that. Okay. Does that answer your question, Chris?
Yes.
Wonderful. There was another gentleman that wanted to ask a question.
No, Chris asked, she cleared, she got,
She
'cause
clarified.
I
Okay.
just jumped on, I heard the last the tail end of what you were talking about, Deborah, and then I was like, okay, great, so, okay, but she clarified, you clarified.
Okay,
Thank you.
wonderful. All right, thank you, James. All right, next question.
Deborah, I got a question. This is Barbara Dyer, and welcome back.
Barbara, kisses for helping me out while I was out. Thank you so much. I heard you had a wonderful session in broker chat, so thank you so much as always.
You're more than welcome, and again, welcome back. Great to have you back. And so, my question though is that okay, the example you just used for the 2.5% for the commission. So would the buyer make up the other 3%? The other 0.5%?
That's your business.
Okay.
I'm only talking about if you're going to the listing agent and you're not asking your buyer at all.
Okay.
Yeah. All right. Everyone understand what Barbara was asking? All right. So it looks like Amy's in the lead with 1,000 points. Oh, nope. She's tied with Joseph. All right. Let's see if we can break this tie. The rest of you are slumming. Come on, let's get it together. All right. So this gives you, if you wanted to go and look at let me see if that's in your way. Let me move this up a little bit. So selling agents are free to negotiate their commission. What's prohibited is if you are trying to change the commission that was offered and putting that in the contract. So this is the text that goes along with what I was talking about. And so when Chris said, so I can write in the commission, in the contract, if you look at the blue, highlighted blue, it says, this is to confirm or acknowledge that the listing broker and selling broker have previously renegotiated the commission to be paid by the listing broker to the selling broker and in the amount equal to blank % of the sale, or if it's a dollar amount, you would put dollar amount. So that's if you want to take a snapshot of that screen or screenshot of that, that's something that you could put in the contract, or you may already be binding and you want to go back and negotiate that, then you would do an amendment and add something like this, or you would use the ICA, also known as the instructions to the closing attorney, and put that in the special steps. Which, by the way, when you make an offer, you should always be including the instructions to the closing attorney. Too many agents wait until, it's a couple days before closing and scramble to get this. I like to know what I'm being paid when I'm making the offer. And I'd like all of that signed off so that there's no confusion. And then the attorney receives it, everybody receives it, not the buyer, but the attorney, so that they know who they're paying and how much they're paying. So if you're not doing that, you need to add that to your systems and as part of your offering process. All right. Let's see if I can get the next question. Can a departing broker contact his or her clients without permission from the qualifying or managing broker? So God forbid you leave Keller Williams, or maybe you've come from somewhere else and you contacted your clients after you left the company. Can you do that? Got 20 seconds. Now, you may not have even thought about this, but during the beginning of the year, a lot of people move around, make changes, go to a better company, go to a smaller company, and you may have some clients. And, now I'm not talking about policy, what an office may have as a policy. I'm talking about what license law is put in place for us. All right. I'm ready to switch screens. Everyone has answered, all your answers locked in. Broker Chat reality show. Can a departing broker contact his or her clients without permission from the qualifying or managing broker? The answer is no. Now, let me tell you the proper way. So I started at Century 21 when I got my license in 1996. And I knew I was leaving to go to Keller Williams because it was Keller who I'd never heard of it, but I had did my research and I was like, I don't think this company is in Atlanta. And then I met a lady that was opening the East Cobb office, which is where I started. And I was also the team leader there for 4.5 years. And I called my clients. I had not left Century 21 and said, I'm thinking about leaving because I had a few listings and a few buyers. And I'm thinking about going to another company. Do you have a problem going with me? that is allowed because I'm still with Century 21. Had I left Century 21, gone to Keller Williams and called the broker's client or customer to move, that's inducing. Now, if your brokerage says, like Keller Williams, when you go, your listings and your buyers can go with you. If you are under contract, you cannot. That's a policy because it involves earnest money and so on and so forth. And I say this for Midtown. If you're from another office, you want to check with your office, but I'm pretty certain it's similar. Okay, so the difference is the answer is actually no. You cannot contact someone when you leave to say, hey, or send out a postcard saying, I'm now at such and such. You are violating that agreement. And your seller, and I know this for a fact, not for me, but I know there have been instances where an agent left a company and the seller did not want to leave that company. They preferred that particular brokerage over another. So you have to be very careful about inducing someone to leave a company. We all know we're the company, don't we? We're under the umbrella of Keller Williams, Century 21, Remax, whatever it is. We all know we're under that umbrella, but I'm explaining to you the correct way to do things according to license law to keep you out of trouble. Any what's from that question?
When you say clients, do you mean clients that you're currently under contract with, or just
Clients or customers? It doesn't matter. I'm saying clients, but it should say clients or customers.
But that you're currently under contract with?
If you're currently under contract with someone and you leave, you have to talk to that broker to say, okay, I'm going here. And that broker might say, okay, you can go, but your transaction stays here because everyone has an independent contract.
But your database is your database, like
your database is your database, yeah. But you don't want to contact people that you are currently in some type of situation, some type of agreement.
Got it. Thanks.
You can do it before you leave. You're not supposed to do it after unless you have a written agreement or written permission from that exiting company to take that client or customer to the new company.
I have a question. So what if not that I'm leaving, I would never leave Keller Williams, but what if I have a listing agreement and it's ready, it's gonna go live in like 2 months and I decide to move within that time period? Would I have to leave the listing with Keller Williams? And if so, who would take over it?
So first of all, Keller Williams believes in your listings, your leads. That's never changed. So if it hasn't gone live, but you've got a signed agreement, then the brokerage technically is supposed to have that listing, but we don't hold your listings. If you wanted to move that listing and the seller is willing to go with you, then we would release that listing as long as it's not under contract. It's only the under contract, guys, because it has to do with earnest money and trust accounts and stuff like that, moving money. It can be done, but it's too messy, so we don't allow that. Does that answer your question?
Yes, thank you so much.
You're welcome. All right, let's move on. Let's see who, everyone got that. So, okay, Jay, Chris, and guess 130, let's get you on the board. Here's the next one. So here's the answer to what we just discussed. So whenever you terminate an affiliation with a firm, you want to make sure that you check with your broker what you will be able to do with your clients or customers that you already have under contract, and maybe something that you already have signed, but in that 2-month period, I'll use that example, you've decided to go somewhere else. Will you be taking that with you? Don't forget, your seller and buyer have a say in this as well. More than likely, they've bought into you, so they'll go wherever you go, as my clients did. But at the end of the day, with Century 21, they immediately, because that's a different type of company, they immediately started contacting my database. But I contacted my database after I left. They weren't under contract, so I could talk to them. It's just the things that are under contract that you can't go back and talk to. Is a licensee obligated to notify a co-op agent when an offer has been presented? Let's see what you say about that. Is a licensee obligated? Remember word problems, you guys, in school? I hated them. It was always that one word that would get me. Is a licensee obligated to notify a co-op when an offer has been presented?
No. Okay.
Somebody said no out loud.
It's
All
saying the poll is locked.
It is. It shouldn't.
Yeah.
I can't press my answer, but it's
Because
okay.
the timer ran out. When the timer runs out, it locks, so you can't put any answers in. All right, so I got a yes, I got a no, oh, half and half, and then 50% of you said maybe. Let's see what I say about that. Let's see so Stephanie's got it right. All right, Chris and Guess, we're gonna get you on here. So let's take a look at it. To be clear, it's not a license law requirement, all right? But it is one of the most common complaints at GREC. So why not largely eliminate this potential for a complaint by saying something like this? This is something you could send in an email to the co-op agent. I want you to know that we received your counteroffer or your offer this day and delivered it on the same day, or if there's a date you want to put that. You can also use the new form that we have that came out, I think, last year, year before. I feel like it's still 2020, so I have to think about what year are we in. Request for confirmation of presentation of the offer, or if they've explained to you that they've submitted it, then can you at least tell me if you are countering me or if you've rejected it? And we have two forms for that. F-288 is the request, F-289 is the notice to reject. Both of these are very underused forms, and I've been using the notice to reject for umpteen years, probably as long as it's been out. And the reason I use that, I don't care if I have multiple offers, I send every single agent a reject, or if I'm going to do a highest and best situation, I will send this notice to reject. And in the special stip, you don't see the whole form, but there's a section where I can say, we are taking highest and best by 1:59 p.m. on Tuesday, or whatever time I put on there. So if I get your offer at 2 o'clock, you're late. It'll still be presented, but the time frame is important when you have multiple offers. Okay, you still have to present because we are bound to present all offers. But as each offer comes in, I use a spreadsheet saying, you know, Barbara came in from Keller Williams. She made an offer of this. They're asking for closing costs. They can close in 5 days. James came in at, 1:55 and he made an offer. He doesn't need any closing costs and he can close tomorrow. James wins. Okay. All right. Any questions about this or any of these forms? All right. Are you using these forms or are they new to you? And does anyone want to share how they're using it?
Never heard of them. They're very new to me.
Okay. So pull those two forms out and take a look at them because it'll make your life easier. Because I guarantee many of you on this call have either wondered, did anyone receive my offer? They're not responding. I can't get in touch with them, blah, blah, blah. This is what you can do. And then the agent will forward this on. Now, I do have a little controversy. Barbara knows this. I've said it before about the request. A lot of us, when this form came out, would prefer to see the seller sign it, but it's the agent who signs it. Not that I don't trust my fellow colleagues, but I would prefer the seller signing this form if the contract committee could ever bring themselves to take another look at F-288. Barbara, do you have a comment about that? Have you heard that before?
I have, Deborah, so go ahead and send us another request and I'll submit it to the Farms Committee again.
Okay, well, I'm verbally, which we know that's not, but I'm letting you know I'm going to send it again because I really do think a seller should sign it.
Oh yeah, when you send it this time, make sure you put me on the email.
I will do that. Thank you.
Okay. Oh, you're welcome.
In case anyone doesn't know, Barbara Dyer is part of the contract committee. No, she doesn't write our contracts, so don't send her ugly messages, but she does sit on that board when they discuss any problems we're having with contracts, any changes we need to have, you know, that type of thing, along with our counsel, Seth Wiseman with Wiseman Law. All right. Is a licensee obligated to notify the brokerage before buying or leasing property? Now, you only have 20 seconds, so I'm letting you see the question here. So get ready to put your answers in before the poll locks you out.
Is
Go.
this like for personal buy, like for yourself?
Yes, yes. Ten seconds. All right, you should be locked out. So let's see the answers. Yes. So some people said no. All right. So let's look at the answer and what license law says. Well, let's see the leaderboard first. So everybody's on the leaderboard now. All right. So license law requires licensees to notify their brokers in writing before they buy or lease. Now, as the managing broker at my office, I notice I don't get a call until you're already under contract and you're ready to close and you want to use your commission for part of your closing costs or whatever you're using it for. And then there's a scramble that I need to hurry up and get you a letter. Okay. What should happen is you should be letting the brokerage know. You can let, in our office, it would be Tyra or Raven or someone like that, that you, and copy me that you're going to be purchasing 123 Main Street. Okay. Now you go about your business negotiating and do whatever you want. However, if you decide you want to not take the commission and you want to use that, who does the commission belong to in a transaction? Anyone?
The broker?
The broker. Now, we all, including myself, use lazy language and we say, my commission, my client, my customer. It's not our customer. It's not our commission first. It belongs to the brokerage. And then we have an independent contract spelling out how we will split that once we bring it back to them, correct? But we're used to DAs and all that kind of stuff. That's just semantics. Technically, it belongs to the brokerage. We have an independent contract that tells us we're 70-30 or whatever your split is and whatever fees the office charges. So if you're going to use your commission, first, let's not have an attitude with the broker about it's my money. Not yet, not so fast, young grasshopper. It's not your money yet, but guess what? We're going to let you use it because we're a company of entrepreneurs. We want you to buy a home. We want you to buy real estate and all of those type of things. That includes leasing. And I guarantee people are leasing and they're not letting their broker know. Now, the reason you're probably not letting your broker know, because very seldom does a lease give you some type of money, but maybe they are. Okay. But this is a license law thing, not a GREC thing, but a license law thing. As you can see, regulation 520-1-11. So you may have already violated it. I won't tell anyone. All right. So the closing attorney also will need permission to use that commission, because all the closing attorneys in this town know that when they're closing a transaction, they are sending a check back or a wire back to your brokerage. If you have a DA, of course, they are given permission to break that commission down into a check for you, FMLS, and whatever else you have to pay. Okay, and however you deliver that to the office. Usually if I go to a closing and I have a DA, I just tell the attorney I'm taking all the checks back to the office and they take them back. This recent one I had, they wired or mailed their money separate and sent me mine separate. So at the end of the day, in writing, what we forget is everything is in writing because we move too fast in technology. We move too fast with our cell phones, talking all the time, texting all the time. Everything must be in writing because as the managing broker and the qualifying broker, which is Tom Fulkerson, we can't fight for anything that you said. We don't need your text feed. We can't go to court with that, but we can go to court with writing, okay? So what happens in the Midtown office, and the rest of you, if you're in a different market center, you'll need to find out how that works. You will contact me. I already have a template that I will write that letter. I'll need your address, the address, how much is the commission? How much of the commission do you want to use? And then I write that up and send that right back to you. It has to be signed by the broker. It can't be signed by the team leader. It can't be signed by the front desk. It can't be because if something goes wrong, and it goes to Greg for whatever reason or somewhere, they're going to wonder, well, who is Sam Smith? And it'll get rejected. Okay, I've had that happen before where I was called and they said, oh, such and such closed it, signed it, and they rejected it. Yeah, because they're not the broker of record when we say that. There are lots of associate brokers running around, but the person who's responsible for what you're doing in the street is the qualifying broker and then your managing broker. And your managing broker could be your team leader as well. So I don't know in every market center how it works. Stephanie, go right ahead.
Yes. So if you haven't capped and you buy a home, can you use 100% of the commission, or is it still the split? How does it work?
That's going to depend on your market center.
Okay.
In our market center in Midtown, we have a personal property policy. And so we do send that to you. And there's a small administrative fee that we charge. I think it's like $500. And then the rest you can do whatever. If FMLS is involved, you still have to pay those. Well, no, I take that back. FMLS, if you're buying, they will waive those fees. And there's a form for that. You can either do it online or we will do it for you. I think either Raven or Tyra does it for you in our office. And then I think that's it. So, and of course, if there's any other fees, like a referral fee or something like that, then, you would have to take care of that. So I can't really answer specifically whether you're capped or not. I don't think it really matters. It just matters that you take care of the fees that we're asking you for. But we don't, in our office, if you're not capped, that has nothing to do with you buying your property. It's the personal property exhibit that we give you, and you follow that. Because we're trying to encourage you to be entrepreneurs buying property, not discouraging you. Does that make sense, Stephanie?
Yes, thank you. I was asking about the personal property policy stuff
Yes.
that you mentioned. Okay,
Yeah.
thank you so much.
Yeah, we have that. And so, for those of you that are not in the Midtown office, you may want to ask, what is our personal property, policy if I should buy my own property? They either have it, they should have it in writing, or someone should be able to tell you that. Most likely your MCA can help you with that as well. All right. Must the licensee keep security deposits they own in a trust account registered with the broker? Must the licensee keep security deposits they own in a trust account registered with the broker? Let's see what you say, 20 seconds.
I don't even understand the question.
So let's say that you own some properties, like rental properties, and you have security deposits. How do you hold those security deposits, and how are you letting your broker know?
Gotcha.
So I'm asking, do you have to keep those deposits in a trust account registered with your broker? All right.
Yeah, I just want you to know that I'm refraining from answering.
Now I'm curious, Now, if I'm saying something wrong, you jump in.
Oh, most definitely I will.
Okay. All right. So 25% of you said no. I want to hear from the no's. Because the answer is maybe. So some of you are going, maybe. It's not a complete yes. You'll see in a few minutes. But I want to hear no. I want to know why the no's.
Well, I said no because of if they own their leasing property and they own LLC, they should have their own escrow and not commingling with the broker. That's the reason why I said no.
Okay. All right. So according to Greg, when you have property, you must register that money with your broker. Now, again, every market center has some type of policy also on how to handle that. So when you decide you're going to buy a rental property, or you move to Keller Williams and you have rental property and you're bringing it with you, you have to report that to the broker. All right. And every office is different as to how they audit that. When I was team leader in East Cobb, we did that once a year in October. That was the time for me to check, have you gotten married and changed your name? Did you move? Did you buy property? Do we have copies of your accounts and so on and so forth? Are we holding the money? All those different things, we would do that because that at East Cobb, I was the qualifying broker. So that was important because that's on my license, that if you're not doing this properly. Now, here's what I've run into of late. Let's say you're married or you have a significant other and you both decide to buy a rental property. You're licensed, but the spouse or significant other is not, and your name is not on the LLC. Listen to me, not on the LLC, and your name is not on the rental property, but you're probably sharing those funds coming in some way. You do not have to have that registered with the broker because the spouse is not licensed. Okay, look at the very last line on this explanation. If the licensee spouse or significant other owns and manages the property and the licensee is not the owner, that means your name is not on it and you're not a member of that LLC, the spouse does not need to deposit those security deposits with the broker. Everything else, just think of everything else, yes, you do. That's the only instance in 520-1-08. Barbara, you want to chime in or no?
Great explanation.
Okay. I would screenshot this because right now we're in that market where you might be having a hard time finding good deals, but there are good deals out there to still be had. And more and more people are starting to buy rental properties and things of that nature. And you may or may not be handling this correctly. And the best way to lose your license is mishandle earnest money and mishandle trust accounts and mishandle security deposits. When I was broker in East Cobb, I had a lady that ended up losing her license because I got a complaint on her from someone about their deposit. And I think she was already an agent when I took over as team leader. So when I did my homework, I found out she had had a complaint before mishandling the same, she had already been sanctioned. And so, shame on you the first time, you don't get a second time with Greg. And she did it again and lost her license. So you really want to be careful. And if you don't think people lose their license, you can go to the Greg newsletter and see the list of people. And there's 47 pages of people that have lost their license or it's been suspended or revoked.
You're right, Deborah. We are real serious about that money.
Yeah, the two things, there's a lot of things that all of you get upset about with other co-op agents and you're valid in your feelings. However, your feelings will not be valid when it comes to messing with trust accounts and earnest money. That is just not tolerated. All right. Any questions, confusion, or feedback on this? All right. So share this in your market centers if you weren't aware of it. All right. Can a broker pay a referral? Oh, this is my favorite. Can a broker pay a referral fee to a non-licensee for referring a customer or client? We all want to do some marketing postcards, newsletters, social media. Hey, come to my such and such. For a referral, I'll give you blah, blah, blah. Compensation, commission, so on and so forth. And you think nothing of it. So what's the answer? Can a broker pay a referral fee to a non-licensee for referring a client or customer? 14 seconds left. All right, we are locked. Let's see what you said. No, but there's some maybes. Interesting. I want to hear from the maybes. Somebody brave enough to tell me their thoughts behind this question and why they said maybe. There's no Greg police on this call, just learning. All right, so let's see. Oh, Stephanie said, booyah, Amy. All right, so License law specifically provides that a licensee can be sanctioned for paying a commission or compensation to any person for performing the services of real estate licensee who has not first secured the appropriate license. So in other words, they didn't get a license, you're not supposed to be paying them or compensating them anything. Okay, so in other words, you can pay a licensed person. So let me give you an example. Say you are inactive in GREC. Can I pay you a commission? Inactive in GREC.
No.
You cannot. Let's say you are in the holding company and you're active, but you're not a full-time agent anymore. You don't have a lockbox and FMLS access and so on, but you're in the holding company as an active license. Can I pay you a referral fee?
Yes.
Yes. All right. Let's say your aunt says, oh, you know what, Chris, my neighbor needs to sell their house. I would like you to pay me $1,000 for the luxury of getting that name and number. Can you compensate your aunt with a commission or let's say a gift certificate for dinner? I don't know, tickets to Beyonce, can you do that?
I want to say I can't give them a commission, but can you give them a gift card as long as it's under $25?
So you're talking about an IRS thing.
Oh,
You're
okay,
not
so that's a
talking
no.
about license law, okay?
That's a no.
That's a no, because it's saying, so look at the bottom here is sending a referral source a gift certificate for a nice dinner. Technically, if you send them something for a dinner, you should be there as well. All right. But we are not going to go give, you could say, hey, I was thinking about you. Happy birthday. Here's a nice dinner. Yes, you can do that. But if it's tied to giving a referral, you want to stay away from that.
Okay.
Thank you is good enough because you don't need to lose your license over one transaction. Okay. Any other thing of value really is a no-no according to Greg.
Okay.
And if they were to investigate you, they get the gift certificate, Chris, but they most likely, if they wanted to, depending on what it is, maybe even depending on the price point, they might say, we feel like this is a thing of value for being linked to a referral. But have I just given a gift card to one of my clients saying, hey, I was just thinking about you. I just want to let you know I have a new real estate service in case you ever need anything, like I'm doing design services now for my clients, or Keller Offers or Keller Concierge. By the way, I was just thinking about you. Have a cup of coffee on me. But I didn't tie that to send me a referral. Does that make sense? Or people that have, what is it, the party, what do you call it when you have like a appreciation party? Is it an appreciation party, or are you trying to tie it to referrals? So you've got to be very careful about using that word referral.
So Deborah, let me ask this question.
Mm-hmm.
So if I sent a letter and I put a $5 Starbucks card in, and say, hey, thank you for the referral. My thing is that I need to leave off the word referral, period. Just say, hey, thinking about you, enjoy a coffee on me.
When I send things out like that, I don't use the word referral at all. First of all, you've put the smoking gun in writing.
Right. Okay.
Okay. So I would steer clear of that, because I'm showing you the GREC law right there, 43-4025. It's prohibited, and it's done every single day. Amy, your hand is up.
Yeah, I guess you sort of referred to it, but I've heard of wanting to have like VIPs, the people who give you many referrals and wanting to do something special for them.
You break them into groups of 5 and take them to dinner, Capitol Grill or somewhere nice, Nobu, something like that.
But we don't have to talk about how you're all here because you are super referrers.
Nope. Here's my script. You are all my VIP clients, and I thank you so much for being here tonight. And I just wanted to share my love back to you, and that's it.
Okay.
That's it. If they know, like, and love you, what are they going to do?
Keep
Send you
referring.
more referrals.
Thank you, but we don't need to talk about that. Okay, does that make sense, everybody? Stephanie has her hand up. Go right ahead.
Yes, so I saw on social media that this agent had a home seminar, and she said how so many buyers walked away with like $500 or $1,000 towards their closing once they close with them. I mean, that's not allowed, right?
Now, what else did we learn in pre-license? Because I'm a freak of nature, I still remember it. That when you do any type of advertising, who needs to look at it?
The
Your
broker.
The broker.
How many of you have ever let your broker look at your marketing? Don't answer that out loud. You see what I'm saying? So I guarantee you that person who did that did not run that by their broker. And that's why we see so many of these things out here. If I sat around checking everybody's website and social media, we probably wouldn't, we'd shut down. We'd have 2 agents working. You know, I'm not saying everybody's doing it on, you know, on purpose. This is why we review these things. Again, I'm a freak of nature. I still remember this stuff, and I'm always staying in learning mode. However, we're also out here selling and listing and so on and so forth. And we just do things automatically for convenience. And we forget, I don't know if I can say, I'm supposed to say that or do that. Then when we see our colleagues do it, oh, sure, we can do that. And you're not supposed to. Okay. All right. If earnest money is not deposited by the due date and the buyer cancels the contract during due diligence, is the buyer in breach? And do they, I'm going to add on to this, do they still owe the earnest money? If earnest money is not deposited by the due date and the buyer cancels the contract during due diligence, is the buyer in breach, and do they still owe the earnest money? 10 seconds left. All right, answer is locked. Let's see. Yes. Oh my gosh, yes. So here's something I'm seeing a pattern that, and we just had it this weekend, where the earnest money was due on Friday and the due diligence was over Sunday. The buyer did not deposit on Friday and then canceled on Sunday, so they think they're good. The agent thought they're good. Seller says foul, okay, and you still owe the earnest money. And because you never deposited it, it was a breach of the contract. You know, you write a contract for a reason, right? You have dates in there for a reason. And even if your client says, you know what, if I go out here and look at this, I'm canceling, and they drag their feet on depositing the earnest money, then you have to let that buyer know, by the way, if you don't have this deposited by Friday, you're in breach. So a buyer is going to say to you, I don't really care. I didn't give you any money, so try to collect it. Well, the seller could sue them, okay, and make their life miserable. And that is going on right now. I don't know how many of you read in the news, but, you know, not to scare anyone or be Debbie Downer, but more and more people are suing brokerages and real estate agents because they're pissed off about 2020 paying too much money over ask. I don't know who suggested that nonsense, but it happened. And now they're pissed because the market has shifted. So if someone says, it's your job to pay attention to your dates. Too many people are letting the transaction coordinator or their assistant monitor that. They are not on the contract, you are. So it's your little red wagon, not, and this is what I get, well, my assistant, stop. Your assistant has nothing to do with this transaction. The last time I looked at your contract, it had your name and a co-op agent's name. Those are the only 2 people involved here. So you need to be very clear that if you are passing those things off to an assistant, even if that assistant is licensed, all that means is that they understand how to work the contract and so on and so forth. You are the licensee in that transaction. And the only person that Greg is going to come after It's the licensees involved in the transaction, not your coordinator. Okay, earnest money is the quickest way to lose your license. Be diligent when you look at those dates. If you feel like those dates and you're saying earnest money is due on a Friday and it's running into a weekend, then make it a Thursday so that you can make sure that happens. You can also amend the contract to say, okay, earnest money is not going to make it on Friday. Let's make it on Monday. But when you pick those dates, make sure your client is going to be able to deliver. If they have to get money from a 401k, or I don't know, they're traveling and they can't get this money wired or whatever, you need to be on top of that, or they need to terminate before that happens, or they're going to be in breach of the contract. All right. So I see a hand up, Barbara.
And Deborah, can you, and I don't know if you're going to talk about this next, but can you also talk about what happens when the earnest money is not turned in, that it is not an automatic termination of that contract?
Correct. You could go ahead and say it.
Okay, because when that earnest money is not turned in, there's a couple of things that need to happen. If you get the earnest money after the due date on the contract, then you should do an amendment acknowledging and all parties should sign. And if that earnest money is not received by that due date and it is terminated and so on and so forth, it is, I'm sorry, if that earnest money is not received by the due date, it is a breach, but it is not an automatic termination of your contract. There's a time frame built in there that says you have to notify the other party that you did not receive that earnest money. They still have a certain number of days to respond back to you. And after that time frame, if they don't, it can be terminated after that time frame.
Right, right. So Barbara's talking about, so that's why we have a form called notice or notification. It's called notice. Anytime there's something in the contract that you need to notify someone, the check bounced, or the wire didn't happen, or the certified funds didn't happen, that kind of thing, you send a notice and there's a 3-day correction. So, and then if it's not, then yeah, now the seller can come after the buyer. But guess what? Remember from, I know I keep saying this, pre-license, you don't have to give money for earnest money. You can give a virgin and a cow, okay, for compensation for buying that person's, house. But we use money in 2023. And so when that doesn't happen, there should be some paper trail to say, oh my gosh, it's Friday. But what happens, everybody picks up the phone, they call the broker. There are things you're supposed to do first before calling the broker and complaining. It's send the notification, because I usually ask that agent, did you send a notification letting them know? The contract, the purchase and sale agreement says over and over and over again in writing, not pick up the phone, not text, not email, in writing. That's what your blank notice form is for. Say, let me just let you know you breached the contract. Now, what are you going to do on the other side? Okay, that is the paper trail, so that when you do come to the broker and say, on Friday, I told Deborah that she was in breach. It's now Monday. Here's broker, here's the contract. Here's when I notified them, because now I have something in writing with dates on it, with timestamps on it. Okay, and that's what happens when we use too much talking and technology. Okay, sorry about that. That was my alarm. All right. So this is where I'm seeing a lot of the problems. The earnest money, where we're saying it's going to be given at the offer date, binding date, or whatever, and then due diligence. They're trying to get out of the contract during due diligence, and they haven't turned the earnest money in on time. They think, okay, well, I'll get away with it because now it's due diligence, I want to cancel. And in the example I had from this weekend, the agent told the other co-op agent, well, we're going to terminate. Okay, well, that doesn't change the fact that you didn't turn in the earnest money. You're just letting them know you're not moving forward. So they just thought that was okay, and it wasn't. All right, can a broker licensee induce a seller or buyer to break an existing listing agreement? And 20 seconds. Can a broker licensee induce a seller or buyer to break their existing listing agreement? So can you ask a seller, if a seller says, I don't like so-and-so, I like you, I want to break my contract and work with you.
Oh,
Somebody
I
fell on
think
the
I
floor.
I think I misread that, Deborah.
That's okay. All right, can a broker licensee and do, oh, yes. All right, the answer is no, you cannot. That's against our license law. And the reason that is because that's a violation. The dictionary defines inducement, a thing that persuades or influences someone to do something. And sometimes the seller will ask you, your job is to tell them, I can't tell you how to do that. You'll need to talk to your broker. You'll need to talk to your listing agent. And then once you take care of that, then we can circle back around, but you can't induce them to do anything. Barbara, your hand is up.
Oh, I'm sorry, honey. Let me take it down.
Oh, okay. All right. Any questions about that? That's just a no. So I'm not, there's no other question, anything else about that. Offering any kind of advice, any of that? No. Can you talk to a seller who calls you? Yes, but you can't cross anyone's listing agreement. So if you're prospecting or someone says, hey, I want to ask you a question, you aren't supposed to cross anyone's, because you know what they're going to do. They're going to go back and say, you know, so-and-so said, and now you're going to go, why are you talking to so-and-so? They've crossed my listing agreement. All right, Stephanie?
Are we allowed to ask them how long did they sign the agreement for?
Yes. Yes. All right. Can a licensee communicate and negotiate to another broker's client or customer? So what this question is saying is, in the event, this happens a lot. You send an offer or you're trying to reach an agent and you're calling, you're not getting a call back, you're trying to submit an offer and you can't reach anyone. Can you contact that seller directly or that buyer directly? All right, answer's locked. No. Can you communicate? Or maybe the maybes win, 25% of you. So let me explain that to you. So let's say that you do realize there are brokerages out there that only give a la carte service, meaning I'll give you a lockbox for a fee, I'll do this for a fee, but you'll notice in private remarks that you're directly contacting the seller. So that's why the answer is maybe, because if you have a exclusive agreement and you are offering full service, you're not supposed to cross that agreement. But if that broker or agent is not offering full service, then you can go direct. Now, remember when I just said document, document, document? If you say, this is what you typically do. You can't reach the listing agent so you can present your offer. So you call the broker and you want the broker to call the broker. You have the right that if you document that you've called this agent for 3 days and you can't get them for whatever reason, you can go directly to the seller and say, I have an offer, but I cannot reach your agent. Could you please help me reach your agent? Can you tell the seller that you have an offer? Yes, you can. Can you send the offer directly to the seller? No, not if it's an exclusive listing agreement. All you're doing is saying, I have an offer. I have documented for 3 days. I've tried to reach that agent and I can't. Could you please help me? Seller says, okay. They call their agent and they can't reach their own agent. Then then the seller comes back to you to say, hey, I can't reach my agent either. Then you can move forward. But before you move forward, that's when I would bring the broker in. Just so we make sure we've covered the bases and your broker knows that you've done everything you could. But what happens is you can't reach the agent, you get frustrated, you call the broker calls their broker, because many times I've called agents and didn't get a call back. I'm like worried, like, are they okay? What's going on? That type of thing. So that is the progression of what you are allowed to do. We learned it in pre-license, but I know unless you just got your license yesterday, you may not remember that that's the process for getting in touch with an agent. Okay. So I would screenshot this because this is a good way for, and I know this happens to all of you. It's happened to me. I know everyone on this call has had this situation. Okay. Is it necessary to get a consent before referring a party for brokerage services? So should you get something in writing before you refer so-and-so from Atlanta to Alpharetta? You don't work Alpharetta and you want to give a referral to someone in your office who lives in Alpharetta. Do you just tell that agent, hey, I want you to work with my client, Sally? Or do you have to ask Sally's permission before you give Sally's name, number, and address to your colleague? All right, answer's locked. Yes, yes. And the best form to use for that is CO11, the referral authorization form. Why? Because it already has the consent information on that form. And if you use any other referral form, it doesn't. And so you want to maybe put something in there saying, you know, you're giving me permission to pass this on. But if you use CO11, it's already on there. Okay. All right, let me go back and see. And Stephanie with 6,438 points, you are the winner. So congratulations. Questions on what you heard today? We're right at the top of the hour.
Deborah, can I say something before
Sure.
we go?
Yeah.
I would just like to say that this was a great broker session. And
Oh, thank you.
all of the topics that you discovered are topics that I fight regularly at the grievance committee. So I would say for everyone to pay attention, be aware. We take these subjects very serious. They do have consequences behind them. And everyone that Deborah touched on today, we've had several instances on at GAR at the grievance committee. So they are very serious and they really come into play when something goes wrong. That's when we're policing ourselves, and that's when we will report things, is when they go wrong. When things are going right, people won't say anything, but it's when things start to go awry. Thanks, Deborah.
Thank you so much, Barbara. You guys, I wanted to do something fun to come back. I love doing this because I know that we forget these things, and I do this because it keeps me fresh as well. So I hope you enjoyed this. The next one will be, I think, the 20, whatever, not next Monday, but the Monday after that. I think that's the 23rd or 28th or something like that. And that will be Tom Fulkerson, who is your qualifying broker. If you have a burning subject that you want us to go over, if you will email me at dblue@kw, that's how you reach me as a broker. Don't use the email that's in FMLS, which is the Across Atlanta. That's for my team. Send it to dblue@kw. Or you can send it to Tom Fulkerson, or I think he is T Fulkerson at KW, and say, hey, could you talk about this? We're always going to talk about things that we see regularly. And I did the 10 questions here because those 10 questions come up constantly. And I mean, there's others, but those are key things that you can lose your license or be suspended and things of that nature. We're not here to scare you. We're here to empower you. I love to empower. And so if you have something that you really say, you know what, you haven't talked about this, and this seems to be, you know, stuck in my crawl, send it to me and we'll discuss it. Any questions before I close out this session? Was there anything that you needed to have answered today or would like to get an answer before we end today? And I did go over a little bit.
I would like to know if we can get these wonderful slides today.
I could send them to you. If you want the slides, send me a request to the dblue@kw and I'll send them to you.
Thank you, Deborah.
I actually have a handout. I can send you the handout where I got this from.
Okay.
I got it straight from Greg.
Okay.
All right, anybody else? Thank you, Niala, for putting this together as usual, and I will see you guys next month. Thank you. Have a good day.
Thank you.
Thank you,